Hi, my name is Nick Mera, Italian lawyer. I focus on international estate and tax planning. We're going to talk about the difference between Italian citizenship and Italian residency. These are two very different topics that might overlap across tax and immigration law. However, they don't necessarily do. You are a citizen of a country where you basically have your connection as a citizen and you have the nationality of that country because you were born there or because your parents were already citizens of that country. And that has usually nothing to do with where you live. It is reflected in the most concrete manner by the passport that you hold. Residency is a different thing. Residency has to do with where you live, where you have the center of vital interest, your center of vital interests, meaning the strongest personal and economic relations. The main distinction about citizenship and residency is that citizenship has to do with your identity, while residency has to do with a place where something connected to your life is happening. There are three types of residency that matter for Italian purposes. There is tax residency, there is immigration residency, and there is civil residency. Let's start with tax residency. Tax residency is defined by the research, the discovery of your center of vital interests. There are some assumptions in Italy that are used by the Italian tax code to define when a person is considered an Italian tax resident. In Italy, they will assume that a person is a tax resident of Italy if that person is in Italy for at least 183 days in a tax year. The tax year in Italy goes from January 1st to December 31st. However, it is a legal assumption. The tax residency for a person who lives in Italy for 183 plus days, that person is assumed to be an Italian tax resident. However, that assumption might be challenged and might not stand in front of sufficient evidence that the presence in Italy does not actually reflect the center of vital interest being in Italy. But the immigration residency is something different, is another level. Some people know about the elective residency visa. So you elect to make Italy your country of residency, where you will live. So you might get the visa, and you at that point receive a permit to be in Italy under an elective residency visa. So you acquire residency immigration permit. Well, that's an immigration residency. And if you have that, but you don't go to Italy, well, guess what? You are not an Italian tax resident just because you hold an elective residency visa for a year. So the elective residency visa is just a visa that allows you to spend time in Italy on a permanent status or a permanent manner, but does not per se entail Italian tax residency. All the pieces together help creating the profile of Italian tax residency or Italian non-tax residency. Civil residency is when in Italy you go to the comune, to the municipality, town hall, and you declare, basically report yourself as being a person who has decided to live in that municipality. So you ask the town hall to put your name in the record of local residents of that municipality. The office where you do this self-declaration is called anagrafe. You go to the anagrafe, you report your name, they put your name on this register, they will send the police, the municipal police within 45 days to make sure that you live where you have declared that you live. And if everything goes smoothly, your residency status, your civil resident status will settle and your name will be on record. Aside from the Italian legal assumptions and options to challenge tax residency, there are also the rules set out by the treaties against double taxation. Italy has signed treaties against double taxations with many countries, including with the US. Italy and the US have determined that when the US and Italy claim tax residency based on their local domestic tax codes, there are certain rules to determine what country's residency that person will have. And the rules established by the Treaty Against Double Taxation are higher on the hierarchy of law compared to the tax code. So Italy, when there is a conflict of definition of tax residency between Italy and the US, will obey to the tax treaty residency rules, which are to a certain extent more flexible with respect to the Italian tax code, because they will take into consideration factors that would not be relevant if the profile was of a citizen from some other country dealing with Italy. In all this dissertation about residency, tax liability, I never ever referenced to citizenship. If you don't live in Italy, Italian citizenship doesn't have any tax implications with respect to the Italian tax system. So really, Italian citizenship has nothing to do with Italian tax liability if you don't live in Italy. If you, however, are a dual citizen and decide to move to Italy, there are some situations where Italian citizenship and dual citizenship combined with Italian residency might trigger different application of the tax treaty against double taxation. So it's really a matter of checking your personal circumstances and determine what your options are. Better if you do that in advance, obviously, because you can set up in place certain strategies to make sure that your profile is not in a gray area, to make sure that everything that you prepare home before going to Italy is going to provide sufficient support to your claim of being or not an Italian tax resident.